We interact with rules and regulations constantly.
Yeah.
Every single day.
Mm-hmm.
You stop at a red light, you sign a lease, maybe you agree to some terms and conditions online without even reading them.
We've all done that.
Right. These are all moments where something we just, call law pops up in our lives.
Yeah.
And honestly, most of the time we just follow along. We don't really stop to think about the fundamental concept behind it all.
It becomes almost automatic.
Exactly. But seriously, when you do stop to consider it,
Yeah.
what is law? I mean, where does it actually come from? And maybe the biggest question, why do we even have it?
Those are the big questions, absolutely.
Welcome to the Deep Dive. Today, we're getting a shortcut to being well-informed because we're diving into one specific source. It's an introduction to political theory, and this source really lays out the foundational concept of law.
A really helpful text for this.
Yeah. So our mission here is basically to unpack this material, pull out the most important insights, maybe find a surprising fact or two along the way, and try to understand the different ways some, incredibly smart thinkers have grappled with this idea of law. It seems simple on the surface, but actually it's incredibly complex.
It really is layers upon layers.
I'm genuinely curious about this one. Law feels like the invisible architecture of society. And I've always wondered about the different ways people have tried to map that out, how something so essential can be viewed from so many different angles.
It is fascinating, isn't it? And you're absolutely right. Understanding the concept of law isn't just like an academic exercise. It's crucial.
Yeah.
It's absolutely crucial to understanding society itself, how power works, how we relate to each other within a political framework.
Right.
And as this source material clearly shows, the debates about what law is, well, they've shaped civilizations. And they continue to shape our world today. So we're going to explore that depth, looking closely at what this foundational text tells us.
Perfect. So our plan for this deep dive then, we're going to start right where our source does. It makes a really important initial distinction between different types of law. That seems key.
It is. Sets the stage.
Then we're going to spend a good chunk of time unpacking the major philosophical schools of thought, essentially. The big ideas about the fundamental nature of law itself. What is it, really?
The core philosophies.
After that, we'll shift gears a bit and look at where this thing called law actually originates, the very sources it springs from.
Where does it come from before it's, official?
Exactly. And finally, we'll tackle its often tricky relationships with other core concepts like morality and liberty. And we'll zero in on that absolutely vital principle, the rule of law.
Sounds like a solid plan. There's a lot to cover there.
All right, let's unpack this then.
Yeah.
Starting with that fundamental distinction our source material immediately highlights.
Right. The source wastes absolutely no time in drawing a clear line between two very different ways we use the word law. It really stresses this. On one side, you have what it labels descriptive or scientific law.
Okay.
And on the other side, prescriptive or stipulative law. And the source really emphasizes that confusing these two can lead to a lot of misunderstanding, especially when you're talking about law in a social or political context.
Descriptive or scientific law?
Right.
Okay, that immediately makes me think of like physics or maybe economics, rules about how the world is, not necessarily how it should be.
Exactly. That's the core idea this source presents. Descriptive or scientific law is all about describing uniformities, regularities in the universe or maybe even in society as they occur under specific conditions. It's about observing phenomena and then formulating a statement that accurately captures how those things behave.
So discovering patterns that are already there in reality.
Precisely. It's about discovery, not invention.
Okay, so how does the source characterize this type of law?
Right.
What are its key features?
Well, according to this material, first and foremost, it exists independently of human will. We didn't, vote on gravity, right?
We didn't invent it.
No. Second, it states that we cannot alter this kind of law, nor can we escape from it. You can't pass a law in Parliament to repeal the law of diminishing returns or something.
Makes sense?
Third, no external agency is needed to enforce it. It just is. It operates universally without anyone needing to police it.
Gravity just works.
It just works. And fourth, the test for descriptive law is whether it's true or false in a factual sense. Is our description accurate? The source notes you might sometimes use right or wrong here, but it's really about factual correctness, not a moral judgment.
So classic examples from the source. I think you mentioned gravity in physics or the law of diminishing returns in economics. These describe observed reality.
Precisely. The source uses those exact examples.
Yeah.
And while we can't change the law itself, we can't make things fall upwards. For instance, we can use our understanding of these descriptive laws. We can use them to our advantage, maybe to serve human purposes.
How so?
Well, the source mentions using knowledge of physics for making, say, mechanical devices, or understanding economic laws to try and improve industrial production. You work with the law, you don't change it.
And this kind of law is only ever challenged or modified by, like, new scientific discovery and experimental proof.
That's right. It's constantly being refined, tested by further observation, more evidence. So for you listening, think about that red light example we started with. From a physics perspective, the laws of optics governing the light or the principles of how the car engine works, those are descriptive laws. They just are.
Okay.
The fact that you stop at the red light, well, that's something else entirely.
Which brings us neatly to the other side of this distinction. Prescriptive or stipulative law. This is the kind of law we usually mean when we talk about legal systems, isn't it? Speed limits, contracts.
Absolutely. This is the domain of rules that determine what an individual should or should not do under specific conditions. These are the rules that are deliberately made, consciously adopted by human societies or organizations, specifically to regulate the behavior of their members.
So these are explicitly man-made rules.
Yeah.
Designed for a purpose.
Exactly. And contrasting sharply with descriptive law, the key characteristics here are, yes, they are man-made, they're adopted by society, and critically, they're enforced by sanctions.
That's right.
If you deviate from a prescriptive rule, you become liable. Liable to punishment or perhaps the denial of some benefit or privilege.
So unlike gravity, which just happens whether you like it or not, if you break a prescriptive law, someone or something, the state, usually imposes a consequence.
Right. And the test for this kind of law is different too. The source says that while initially, maybe in a moral sense, you might ask if the rule is right or wrong, when it's applied objectively by legal professionals, lawyers, judges, the test becomes valid or invalid.
Valid or invalid.
Meaning, is this rule actually part of the established legal system? Is it properly applicable in this specific situation?
And this is where interpreting the rule comes in. I think the source mentions the letter of the law versus perhaps the spirit of the law.
Yes, exactly. The source mentions that the letter can sometimes be supplemented by the spirit during the process of interpretation and enforcement. A clear example given is a penal code, which prescribes punishments for various offenses. That's a textbook case of prescriptive law.
Okay. And crucially, this type of law is changeable by humans. It's not fixed like a law of nature. We can alter it based on societal needs, changing values, maybe a developing sense of justice.
That's a fundamental difference. It might be inspired by custom or conscience or public opinion, but humans ultimately have the power to revise it, amend it, or even abolish it entirely.
We can rewrite a penal code. We can't rewrite gravity. Simple as that.
Pretty much. So for you listening, this is the world of speed limits, property laws, voting regulations, the rules we as societies have created to try and live together in some kind of order.
So the source makes this sharp distinction right up front because essentially in political science, social sciences, and especially in jurisprudence, when we talk about law, we almost exclusively mean this prescriptive type unless we specifically say otherwise.
Correct. It immediately sets the boundaries for the whole discussion that follows in the text. We're focusing on the human-made systems of rules that govern social behavior.
Got it. Okay. So we're zeroed in on prescriptive law, the rules we make. Now, our source material really dives into how different schools of thought have wrestled with the fundamental nature of this man-made law. Like, what is it at its core? This is where things start to get really interesting, isn't it? Revealing these different philosophical viewpoints.
They absolutely do. The source outlines 4 principal schools that have been particularly influential, especially in the Western tradition. Each one offers a really distinct philosophical lens on what prescriptive law actually constitutes.
Okay, what are they?
They are the natural law school, analytical jurisprudence, historical jurisprudence, and sociological jurisprudence. Looking at them side by side really helps us see the concept of law from multiple angles. It's not just one thing.
Let's start with natural law school then. Just the name makes it sound like it connects back to that idea of a higher, maybe even moral order or something.
It does, very much so. The core idea of the natural law school, as presented in our source, is that law derives its authority, its binding force, you could say, from a higher universal law. This higher law is often referred to as the law of nature, or simply natural law.
So it's suggesting that law isn't just about rules agreed upon by a community. It's about rules that tap into something deeper, like an inherent sense of rightness or justice.
Precisely, that's the heart of it. Key characteristics mentioned are that it represents binding obligations that stem from the moral sphere. Now, like scientific law, it's often seen as existing independently of human will, but its character is crucially normative. It deals with how things ought to be rather than just descriptive, how things are.
Normative versus descriptive. Got it.
And it's believed to be discoverable by human reason. It posits a universal standard of justice or right that exists separately from, and maybe even above, any specific human laws or enactments.
The source traces this idea way back, doesn't it? Mentions the ancient Stoics, its use in Roman jurisprudence as a kind of standard to judge positive law against.
Yes, and it was even equated with divine law in the medieval period. The historical thread is long and really significant.
And it didn't stop there. The source mentions Kant in the 18th century.
Right, Kant developed it as an objective standard rooted in our rational nature. And importantly, the source notes that in contemporary discussions, natural law principles are still frequently invoked, particularly when people argue about universal human rights.
Okay. That makes a lot of sense. So when people talk about certain rights that governments just can't take away, that are inherent, they're often standing on this philosophical ground, aren't they? A higher natural law that transcends whatever the current positive law might say.
Exactly. This school suggests there's a standard of rightness out there, discoverable through reason, that law should aspire to. It's not just about what the person in power dictates.
Okay, that's a fascinating perspective. Now, let's pivot to a school that seems to actively push back against that inherent moral connection. Analytical jurisprudence, also known as legal positivism.
Yes. This school takes a very different tack. The source identifies it as having originated and really flourished, particularly in the Anglo-American legal tradition, especially in the 19th century. It views law primarily as positive law.
Positive law meaning law that's posited, put in place.
Exactly. Law that is laid down or posited directly by a competent authority, like a sovereign or a legislature, and crucially is enforceable by sanctions. The focus here is very much on law in its technical structural sense, and it deliberately seeks to separate the question of what law is from the question of whether it's morally good or bad.
So it's basically saying, look, let's analyze law as a system of rules made by authority, and let's not get bogged down in debates about whether those rules align with some higher morality.
That's a good way to capture its foundational stance. It rejects the idea that a rule needs to conform to some external moral order to actually be law. If a rule is properly made by the recognized authority in that system, and it's backed by enforcement, then it is law, period. Morality is a separate question.
And the source notes this even led some early positivists to argue that international law wasn't really law.
That's right, because it seemed to lack a clear, single sovereign capable of commanding and enforcing rules across nations. They saw the natural law approach as, well, unscientific, maybe even mythical, and hopelessly confusing the distinct realms of law and morality.
And John Austin is highlighted as a chief exponent of this view. What was his sort of classic definition?
Austin defined law quite strictly and famously as a command of the sovereign issued within a political society.
A command. Very direct.
Very direct. And following this definition, he concluded that international law, lacking that identifiable sovereign commander, wasn't true law, but merely positive morality. Rules people followed, maybe, but not law in the strict sense.
Okay, a very power-centric view of law there. But the source mentions this view was then modified or perhaps refined by subsequent thinkers within the same positivist tradition. How did Hans Kelsen change things?
Kelsen, another major figure, agreed with Austin on separating law and morality, but he felt Austin's simple command theory was too simplistic, maybe too focused on just orders backed by threats. Kelsen argued that the validity of any specific legal norm, a rule, basically comes not just from being issued by an authority, but from its conformity to a higher norm within a whole hierarchical system.
A hierarchy, like a pyramid of rules.
Exactly. He envisioned this pyramid of norms where lower norms derive their validity from higher ones. So a regulation might be valid because it's authorized by a statute, and the statute is valid because it's consistent with the Constitution. And this hierarchy ultimately traces back to a foundational, assumed basic norm, what he called the Grundnorm, which isn't itself legally created but is presupposed to give validity to the entire legal system.
Wow. Okay, so it's more about the internal coherence and structure of the legal system.
Yes, but like Austin, Kelson firmly separated the question of a law's validity within that system from its moral content. A law could be perfectly valid according to the Grundnorm and the hierarchy, even if it was considered morally reprehensible.
So Kelson saw law more as a coherent, self-contained system of norms rather than just the boss giving orders.
Exactly, it's about the internal logic and structure. Then comes H.A.L. Hart, another towering figure discussed in the source, who offered some really significant critiques of both Austin and, implicitly, some aspects of Kelson's view, too.
Okay, Hart. What was his main issue with Austin's command model? It seems quite influential.
Hart, particularly in his major work The Concept of Law, argued that Austin's model, which seemed largely based on criminal law, prohibitions backed by threats of punishment, was just too narrow. It couldn't really capture the full scope of what law actually does.
Also,
Hart pointed out that a massive part of law isn't about telling people not to do things under threat. Think about civil law, the rules governing contracts, marriages, wills, property. These aren't primarily about commanding behavior with sanctions, they're about enabling people. They provide facilities for people to make private arrangements, they distribute benefits, they structure organizations. Law, for Hart, wasn't just about coercive orders, it also conferred powers and facilitated actions.
so law does more than just forbid things. It also creates possibilities, structures relationships.
Precisely. So Hart saw law more broadly as a system of different kinds of rules. He famously defined law as a union of primary rules. These are the rules of conduct, like traffic laws or rules against theft, and secondary rules.
Secondary rules, what are those?
These are rules about the primary rules. They tell you how to make new primary rules, rules of change, how to modify old ones, how to identify which rules are actually part of the system, a rule of recognition, and how to apply the rules and resolve disputes, rules of adjudication. These secondary rules provide the framework, the structure for the whole legal system.
Okay, that sounds much more comprehensive than just commands. And Hart differed from Kelson's basic norm, too.
Yes, Hart moved away from Kelson's rather abstract, presupposed basic norm. He argued that the ultimate standard of validity for rules in a legal system isn't some hypothetical norm, but is rooted in a social fact. Specifically, the acceptance by the officials of the system, judges, legislators, etc., of a rule of recognition. This rule specifies the criteria for identifying valid law within that particular society.
A social fact, meaning it depends on what people, especially officials, actually do and accept.
Exactly. The source illustrates this point by noting that an act might be perfectly lawful under English law, but not under French law. This shows, Hart argued, that the standard of validity isn't just an abstract hierarchy, it's rooted externally in the specific practices and acceptance within a particular society and its legal system.
Okay, so Hart grounds the system's validity in how it actually operates and is accepted by those who administer it. That feels more concrete. But then the source brings in Ronald Dworkin as a critic of Hart. How is Dworkin's issue? Hart's view seems quite sophisticated.
Dworkin, another hugely influential philosopher of law, pushed back against Hart's focus primarily on rules. Dworkin argued that this picture was still incomplete. He said that especially when judges face difficult cases, hard cases, where the existing rules don't seem to provide a clear answer, they don't just exercise discretion arbitrarily or act outside the law. Instead, they rely on something else. Principles.
Principles, as distinct from rules.
Yes, and Dworkin argued that these principles are fundamentally part of the law itself, not something extra legal that judges bring in from outside.
What kind of principles? Can you give an example?
The classic example the source uses, which comes from a famous case, is the principle that no man should profit from his own wrong. Imagine someone murders a relative to inherit their money. The rules of inheritance might technically allow it, but the principle prevents it. Dworkin highlighted the distinction. Rules often operate in an all-or-nothing fashion. Either the rule applies or it doesn't.
Right.
Principles, however, have what Dworkin called a dimension of weight. They provide reasons for deciding a case one way or another, but they can conflict with other principles, and judges have to weigh them up. Decisions aren't simply derived deductively from one principle, but principles guide the reasoning process in these hard cases.
And Dworkin argued that the validity or the authority of these principles comes from somewhere different than rules, not just from the rule of recognition.
Exactly. Dworkin suggested their grounding is deeper, rooted in the broader political theory and morality of the society, not just the internal logic or social facts of the legal system, as Hart described it. He argued, for instance, that constitutional standards are often based on underlying political principles, like equality or fairness, and are therefore subject to criticism and evaluation from that broader moral and political perspective.
Wow. Okay. So the source sort of synthesizes these critiques within positivism. Kelsen pointing to the abstract basic norm, Hart emphasizing the structure of rules and the social rule of recognition, and Dworkin highlighting the crucial role of principles drawn from political morality. It shows that even within this school, focusing on law as it is, there's a really rich and ongoing debate about what that actually entails.
Absolutely. It's about the internal logic, the structure, the validity of the legal system itself, rigorously separated from external moral judgments about whether the law is good. But even then, they grapple with the complexity of what that system actually comprises. Is it just commands, a hierarchy of norms, a complex structure of primary and secondary rules? Or does it inherently include deeper principles, too?
Okay, that gives us a really good handle on natural law versus analytical jurisprudence. Now let's look at the third school mentioned. Historical jurisprudence, sometimes called legal evolutionism. This sounds like it views law through the lens of time and cultural development, maybe.
It does, very much so. The core idea here, as the source explains it, is that the fundamental nature and meaning of law are best understood by examining its historical roots. How has it evolved over time through the social forces unique to a particular people or society? It sees legal systems not as things consciously designed and imposed from scratch, but more like organic growths.
Organic growth, interesting image. And the key figures mentioned are F.C. Savigny and Henry Maine.
That's right. Savigny, a prominent German jurist, is presented as viewing law as an almost mystical expression of the spirit of a particular people, their unique collective consciousness, their race, their culture, their national character. He used the term Volksgeist for this.
The Volksgeist, the spirit of the people.
Yes, and Savigny strongly emphasized custom as the most fundamental, most authentic form of law. He argued it originated spontaneously, almost unconsciously, in the daily life and shared beliefs of the people. Formal legislation, in his view, was secondary. It was just the process of translating that pre-existing popular consciousness into written form.
So for Savigny, law bubbles up from the people's shared traditions and beliefs first and foremost. The state just writes it down later.
That's his core argument, yes. Then there's Henry Maine, a British jurist who the source presents as building on Savigny's historical approach, but also critiquing it in some ways.
Right. In his famous work, Ancient Law, the source says Maine actually rejected Savigny's intense focus on just one particular people's unique heritage or Volksgeist.
Correct. Maine was looking for something more universal. He undertook comparative studies of different ancient legal systems, trying to find broader patterns in legal evolution across different societies. And his key finding, which the source highlights as really central, was his observation that progressive societies tend to move from status to contract.
From status to contract, what exactly does that mean in this context?
Well, the source explains this as a general evolutionary trend. Societies tend to move from an early condition where individuals' roles, rights, duties, and relationships are largely fixed from birth based on their social status. Think of family position, caste, clan membership, things you're born into. They move from that towards a condition where relationships and obligations are increasingly based on voluntary agreements, on contracts made between individuals.
Ah, okay. So a shift from ascribed roles to achieved roles, defined by agreements.
Exactly. So the historical school, whether Savigny's version or Maine's, fundamentally sees law as something that changes organically over time. It doesn't have a fixed, timeless content. Its substance is constantly shaped and reshaped by shifts in a society's underlying institutions, its culture, its fundamental relationships, and its collective awareness. Law is seen as a product of deep historical processes, not just present-day commands or abstract reason.
Fascinating. It adds that whole dimension of time and social evolution. Okay, finally, the fourth school. Sociological jurisprudence. This one sounds very focused on the practical role of law in society right now, maybe its function.
It is. This school takes a distinctly functional approach to understanding law. Its core idea, often contrasting sharply with analytical views that emphasize the state as the ultimate source of law, is that the state is actually not the primary origin of law.
Really? So where does law come from then, according to this view?
Well, the state is viewed more as an agency that recognizes, perhaps formalizes, and enforces rules and norms that already exist within society, often emerging to serve specific social interests or needs. From this perspective, law, or at least the social reality that underpins it, is seen as existing prior to the state and maybe even superior to it.
So law emerges from society's actual needs, its interactions, its group dynamics, and the state's job is basically to identify and enforce those existing social rules.
That's the essence of it, yes. The source lists several proponents associated with this view, like Ludwig Gumplevich, Leon Duguid, Hugo Crabb, Roscoe Pound, and Harold J. Laski. They tend to emphasize law's unique importance as a vital instrument, an instrument for actively solving contemporary social problems and achieving social progress.
An instrument, a tool. And Roscoe Pound is highlighted particularly for his emphasis on law's social purpose.
Yes, Pound was a major figure here. He argued strongly that law should be evaluated and its substance determined primarily by the social purpose it serves, or is intended to serve. He insisted that law must remain open to ongoing interpretation and revision based on society's changing needs and consciousness, so it can effectively promote social progress.
And he had that famous phrase, the proper function of law is.
Social engineering, that's the phrase noted in the source, famously associated with Pound.
Social engineering.
Yeah.
Using law as a deliberate tool to build or reshape society towards desired goals. That's a really powerful and maybe slightly controversial image.
It is. It portrays law as consciously goal-oriented. This school determines law's substance largely by the social purpose it aims to achieve. The source explicitly contrasts this with the historical school, while the historical school looks backward to understand law through past institutions and evolution.
Right.
The sociological school looks forward. It looks to the future vision of society and asks how law can be used as a practical tool to get there, to solve current problems and build a better future.
Okay, wow. So just summing up these four schools briefly, we have natural law, looking upwards to a higher moral order. We have analytical jurisprudence looking inwards at the structure and validity of law as a system created by authority. We have historical jurisprudence looking backwards, seeing law as an organic growth from a people's past and traditions. And we have sociological jurisprudence looking forwards, viewing law as a practical tool for achieving future social goals. It's incredible how many different fundamental ways there are to think about what law even is.
It truly is. And the course's exploration of these different schools really drives home the point that even the very definition of law is deeply contested. It depends heavily on which philosophical foundation you're standing on, what questions you're asking about it.
Fascinating stuff. But okay, if prescriptive law is man-made, as most of these schools agree in some sense, and the sociological school even suggests it exists in society before the state formalizes it. Yeah. Where does it actually come from initially? What are the origins, the raw materials that feed into the legal systems we see today? Our source material lists several key sources of prescriptive law.
Right. The source does discuss this, and it acknowledges there's a bit of a paradox here. Technically, if you take a very formal state-centric view, the state is the source of law because it's the entity that commands, recognizes, enforces, and applies the official sanction.
That's the positivist view, basically.
Largely, yes. But the source notes that other thinkers, particularly those called pluralists, like R.M. McIver, who's mentioned, argue compellingly that law, or at least law-like rules, existed in societies long before the modern state came along, and that the state often just declares or formalizes law that's already there, already operating. So this section in the source explores these pre-state or maybe non-state origins that underpin our formal legal systems.
Okay. And the first one listed is custom. That seems pretty fundamental.
Custom is described in the source as potentially the oldest and maybe the most important original expression of law. Think about modes of behavior that, through long periods of trial and error within a community, were found suitable, found to work. They became stabilized over time.
Habits that stick.
Exactly. They got accepted as the standard forms of conduct, the right way to do things. And critically, human beings within that community came to treat them as binding rules, not just suggestions, but rules you had to follow.
And how were these customs enforced before we had formal state structures, police forces, courts?
Good question. The source notes that enforcement mechanisms in these early communities were primarily social. Things like ridicule, public disapproval, being excluded from community life, or rituals, social privileges. And sometimes it could be much harsher, including severe punishment, even up to execution or banishment, which could mean death. These weren't just polite suggestions. They often had serious teeth, enforced by the community itself.
So social pressure and the collective will of the community were the early police and courts, in a way.
Essentially, yes. The source gives some concrete examples. Think about the fundamental institutions of marriage and family. They were initially based purely on custom, existing long before the state formally existed, although the state later stepped in to regulate them.
All right.
Similarly, rules governing early economic transactions, how you trade, what constitutes fair exchange, these often derive from long-standing social usage before they ever became subjects of formal legislation, and a huge one. The common law of England is specifically cited as being based, in large part, on customs that were recognized and applied by the courts over centuries.
That really highlights how deeply rooted in just basic human social interaction the idea of binding rules can be, long before governments get involved in writing them down.
It shows order emerging organically from repeated social practices, from what people actually do and expect others to do.
Okay, custom makes sense as a primary source.
Yeah.
Next, the source lists religion.
Religion, historically, played an absolutely massive role as a source of law. In many, perhaps most, primitive or traditional communities, custom and religion were often deeply intertwined, almost inseparable. Religion dictated not only how you worshipped, but also provided extensive regulations for social life, for how people should interact, what was forbidden, what was required.
And the source points to things like the close link, often found between the priest and the king or the chief, in traditional societies as evidence of this connection.
Yes, signifying that fusion of religious and temporal authority. It also explicitly mentions that ancient Roman law had very strong roots in religious rules and rituals, and ancient Indian codes, like the laws of Manu, were often difficult to distinguish from purely religious scriptures. They covered both religious duty and social law.
And it's not just ancient history, right? The source mentions contemporary examples.
It does. It notes that even in modern India, for instance, personal laws for Hindus and Muslims regarding critical life events like marriage, divorce, inheritance, these are still largely based on their respective religious traditions, operating alongside the secular state law.
So for millennia, religious beliefs provided a powerful framework of rules, moral authority, and sanctions that directly shaped early legal systems and continue to influence law in some areas today.
Absolutely. For many cultures throughout history, law was religion, or flowed directly from divine commands or sacred traditions.
Okay, custom and religion are perhaps the most obvious historical sources. But a less intuitive one listed next is scientific commentaries. How can scholarly writings actually become a source of law? That seems different.
It is different, but very important, especially in developed legal systems. This refers to the influence of eminent jurists, legal scholars, and publicists. These are individuals who write comprehensive books, treatises, commentaries, where they interpret existing law, analyze its underlying principles, and often raise important questions or suggest solutions where the current law is silent or maybe ambiguous or uncertain.
So they're analyzing and explaining the law.
Yes, and advancing arguments, providing proofs based on legal logic, historical understanding, maybe comparison with other systems. They're engaged in a deep, systematic study of the law.
And what's their impact? The source says their opinions, if they're sufficiently effective and convincing, can actually be treated as authoritative as law itself. That's a strong claim.
It is a strong claim, and it applies only to a very select few whose work gains immense respect over time. But the source makes the point that this does happen. It names influential figures whose writings achieved this status. People like Sir Edward Coke and William Blackstone in England, whose commentaries were hugely influential.
Right, Blackstone's commentaries.
Exactly. And Joseph Story and James Kent in America. Their views, expressed in their scholarly works, were consistently recognized and relied upon by courts when making decisions, especially in areas where the law wasn't clear. Their writings effectively shaped the law. The source even speculates that perhaps some elaborate commentaries on modern Indian constitutional law might eventually attain this kind of high authority.
So, profound scholarly analysis and interpretation by highly respected legal minds can directly shape how the formal legal system understands and applies the law. It's like the wisdom of the experts feeding back into the system.
It really shows the intellectual and persuasive dimension in the ongoing development of law. It's not just commands and customs.
Okay. Adjudication is listed next. This refers to judicial decisions, court rulings, right?
Yes, exactly. This is the process where judicial decisions and the verdicts reached in court cases themselves contribute directly to the body of law. When judges decide cases, especially if they are novel or complex ones, their written opinions often include detailed explanations of the legal principles they're applying, or maybe new interpretations of existing statutes or constitutional provisions. And these explanations then serve as precedents.
Precedents. binding for future cases.
Yes, particularly in common law systems. So in areas where the formal law passed by the legislature is silent, or maybe it's vague or uncertain how it applies to a new situation, judges are essentially filling in the gaps through their rulings.
They're making law, in a sense.
In a very real sense, yes. Their reasoning, the arguments they use, the principles they articulate in resolving specific disputes, these become guides, sometimes binding guides, for how similar cases should be decided in the future. The source notes that judges, through this process, can significantly expand the scope of the law. They adapt existing legal principles to changing social circumstances, making their own distinct contribution to the evolution of the law over time.
And the source gives examples like case law in England, or the decisions of Supreme Courts in countries like America and India as prime examples of this judge-made law.
Precisely. This is the very heart of the common law tradition, the idea that precedent, the accumulated wisdom from past rulings, shapes the law for the future. It's a dynamic process where the application of law in specific concrete cases helps to build and refine the law itself over time.
Okay, that makes sense. Now, equity is also mentioned, and the source seems to distinguish it slightly from standard adjudication, even though it's also judge-made. How is it different?
Right. While standard adjudication generally involves applying and interpreting existing law, statutes, precedents, equity is described in the source as another form of judge-made law, but one that specifically aims to break new ground or provide a remedy where the existing law seems inadequate or where applying the strict letter of the law would lead to an unjust or unfair result.
So it acts as a kind of safety valve, a way for judges to ensure fairness when the rules seem too rigid.
Exactly. It's a mechanism where judges can turn to broader principles of fairness and justice, what's often called natural justice or good conscience, to provide relief in situations where a strict application of the established positive law rules would cause hardship or unfairness. It's meant to supplement the common law, not replace it, by providing remedies in situations the common law didn't adequately cover.
And it's derived from principles of natural justice. We touched on that briefly with natural law earlier. It's not strictly bound by the existing positive law.
That's the key idea. It draws its inspiration from a sense of fundamental fairness rather than just the letter or even the perceived spirit of the existing positive law rules. The source mentions its historical use going way back to ancient Roman law, the concept of equitas, and its continued relevance today, often invoked in areas like contract law or property disputes involving trusts.
And the source actually lists those widely accepted principles of natural justice here, doesn't it, as the foundation for equity.
Yes, it does. It lays out those fundamental ideas that seem inherently fair when resolving disputes. The principle that no person should be a judge in their own cause, avoiding bias. The principle that both sides in a dispute must be heard, audi alteram partem. That a judge should give full consideration to the relevant facts and exclude irrelevant information. That similar cases should generally be decided similarly, consistency. That justice must not only be done but must be seen to be done, transparency. And that a judgment should normally include reasons, not just a bare decision. Equity allows judges to bring these fundamental principles of fairness to bear when the strict rules fall short.
So it adds a crucial layer of fairness and flexibility to what might otherwise be a very rigid structure of positive law, a way to temper justice with mercy, maybe.
You could put it that way. It provides a means to avoid outcomes that would shock the conscience, even if technically allowed by the rules, by allowing judges to intervene based on fairness when applying general rules to specific, complex human situations.
Okay, that's custom, religion, commentaries, adjudication, and equity. Finally, the most obvious one perhaps for us today. Legislation is listed as a source, though the source notes it's perhaps more accurately described as the process of lawmaking.
Correct. Legislation is the most direct, deliberate, and nowadays probably the most voluminous source of new law in the modern state. With the rise of democracy and representative government, you have popularly elected assemblies, parliaments, congresses, legislatures, whose primary job is to enact new statutes, new measures, new laws.
This is probably the source most people think of immediately today, isn't it? New laws being debated and passed by our elected representatives.
Yes, absolutely. This process continuously supplements, modifies, and sometimes completely replaces the existing body of law derived from custom, precedent, or other sources. It's how societies consciously respond to changing needs, implement new policies, and regulate emerging areas of life.
So looking at this whole list, the source provides custom, religion, scientific commentaries, adjudication, equity, and legislation. It's really clear that prescriptive law doesn't just magically appear fully formed from the state. It emerges from this rich, complex mix of deep-seated social norms, historical traditions, religious beliefs, rigorous intellectual analysis, practical judicial interpretation applying principles of fairness, and of course, deliberate political action. It's a much more layered and fascinating origin story than just the government made a rule.
It really shows how law is deeply woven into the very fabric of society, drawing its threads from all these different aspects of human experience, organization, belief, and reason. It's not monolithic at all.
Absolutely. Okay, so now that we've explored what law is, its different potential natures, and where it comes from according to our source, let's turn to its relationship with other really big concepts in our lives. The source delves into the complex, sometimes tense, interplay between law and morality.
Yes, this is a perennial debate in legal and political philosophy, and the source addresses it head-on. Ideally, of course, we'd probably all hope that the laws of our society would align with our shared sense of morality, our understanding of right and wrong.
That seems like the goal, doesn't it?
It does. However, the source makes it very clear that, in practice, laws and moral standards can, and often do, diverge. They aren't always the same thing.
And the divergence can create a real tension for individuals, right? Like when the law requires you to do something that your conscience, your personal morality, tells you is wrong, or forbids something you feel morally obligated to do.
Exactly, that's where the clash happens. The source illustrates this potential conflict with a specific example. Think of a worker who feels a strong moral obligation to support their union's call for a strike, maybe for better wages or safety conditions. But imagine that particular strike has been legally banned by the authorities.
Right.
If that worker joins the strike, they face legal consequences, fines, maybe losing their job for breaking the law, even though they were acting on what they perceived as a strong moral commitment to solidarity or justice. It really highlights that potential painful clash between a legal obligation and a moral one.
And we can think of so many historical examples,
Yeah.
unfortunately, where laws were clearly legally valid within their system, but were deeply, profoundly immoral by later standards, or even by the standards of many at the time. Laws enforcing slavery, for example, or discriminatory laws based on race, religion, or gender.
Precisely. Those are stark reminders that legality and morality are not synonymous. The source also discusses the different scope of law and morality. Law, it points out, is primarily concerned with regulating external actions, what you actually do. It doesn't generally punish your inner motives or thoughts unless they manifest in action.
So things like envy or ingratitude or hypocrisy, these might be considered morally wrong, but they're not usually legally punishable in themselves.
Generally not, unless they lead directly to an action that breaks a specific law, like if envy leads to theft or hypocrisy leads to fraud. But the internal state itself isn't usually the law's business.
Whereas morality, well, that springs more from conscience, from internal beliefs and values, and it imposes duties or standards that aren't always or even usually legally enforceable, like being kind or generous or forgiving.
Right. There's no law compelling you to be grateful, even if morally you perhaps should be. And this source makes a really crucial point here, turning things around a bit. Law can certainly prevent certain immoral acts by threatening punishment, but it cannot make us moral.
You can't legislate goodness into people's hearts.
Exactly. Morality, the source suggests, is something that's nurtured differently through proper education, through a congenial cultural environment, through family upbringing, through personal reflection and conviction. It's not something you can simply impose through legal rules. In fact, the source flips it around and argues that it is often our underlying morality that makes us law-abiding citizens in the first place.
Oh, so?
Well, the idea is that many people obey laws not just because they fear the punishment if they get caught, but because their own moral sense tells them that upholding the law, respecting others' rights, contributing to social order, and playing by the agreed-upon rules is generally the right thing to do.
That's a powerful idea that our internal morality can actually be a key foundation for external obedience to the law, more powerful than just fear.
It suggests a deeper, more stable reason for compliance than just coercion. The source also contrasts the typical sanctions involved. Law ultimately relies on force, or the threat of it, the fear of punishment. Morality's sanctions are usually internal, a guilty conscience, shame, or social disapproval, loss of reputation, social ostracism.
Different kinds of pressure.
Very different. It also notes that law, ideally at least, aims to be relatively clear, definite, and consistent, whereas moral standards can often be more debated, more ambiguous, sometimes context-dependent, and they certainly change significantly across time and place. What was considered morally acceptable centuries ago might be abhorrent today.
True. However, despite these differences, the source emphasizes that changes in law and changes in a society's moral consciousness are definitely intertwined, right? They influence each other.
Absolutely. It's a dynamic relationship. Changes in law can sometimes follow shifts in public morality as society's views evolve. Pressure builds to change the law to reflect those new values. But importantly, the source argues it can also work the other way around. Changes in law can sometimes precede and even help drive shifts in societal moral consciousness.
How would that work? Law leading morality.
Well, the source suggests that sometimes existing widely held moral beliefs might actually be based on outdated thinking or prejudice or superstition. In those cases, law can actually take the lead as an instrument of social reform, challenging those old norms.
Like using law to abolish practices that were once widely accepted, maybe even considered morally correct by many, but are now seen as fundamentally wrong or unjust.
Exactly. The source provides some potent examples from India's history, things like the legal abolition of child marriage, or the practice of widow burning, sati, or untouchability based on caste or bonded labor. These were deeply ingrained social evils, often with some traditional or perceived moral justification at the time. Reformers first challenged them based on moral arguments, certainly. But it was often the translation of these reformist moral ideas into concrete laws, laws that prohibited these practices and punished violators, that created broader social awareness, forced people to confront the issues, and ultimately helped shift the prevailing moral consciousness of the society on a larger scale over time.
Wow, that shows a really dynamic kind of two-way street, doesn't it?
Yeah.
Sometimes morality pushes for legal change, and sometimes legal change helps push for moral evolution in society.
It really highlights law's potential, when used thoughtfully, as a tool for social and ethical progress, not just maintaining the status quo. The source also touches briefly on laws that seem, on the surface, morally neutral. The classic example is traffic laws deciding whether we drive on the left or the right side of the road.
Yeah, that seems purely arbitrary, doesn't it? It's just
Yeah.
a matter of convention for convenience. There's no inherent moral reason for left versus right.
True, the choice itself might be arbitrary, but the source argues that even the observance of such seemingly neutral laws is ultimately underpinned by a kind of moral sense. Why do we mostly follow the rule, whichever side it is? Because of an implicit recognition of an equal concern for the convenience and, more importantly, the safety of all road users. Choosing a side and sticking to it allows everyone to navigate predictably and safely, based on an underlying, perhaps unspoken agreement rooted in mutual respect and a desire to avoid harming others.
Huh. That's interesting. So even the most technical rule about public order might have an underlying moral rationale related to collective well-being or safety.
Precisely. And the source's concluding point on this whole law and morality section is really vital, because law is the primary tool for regulating social life. Laws must, over the long run, adjust and adapt to significant changes in a society's moral consciousness. If laws become too detached from the deeply held values and sense of justice of the people they govern, they risk becoming seen as illegitimate, perhaps tyrannical. They might be frequently violated, lose public respect, and potentially the entire legal and political system could face instability or even overthrow.
That's a powerful reminder that law isn't or shouldn't be static. It has to live and breathe with the society it governs, maintaining some connection to that society's evolving sense of right and wrong. It's a really complex dance.
It is indeed. Never perfectly aligned, but needing to stay in conversation.
Okay, so we've wrestled with law's relationship with morality. Now let's turn to another huge concept that often seems inherently at odds with law. Liberty, or freedom. Liberty is often defined as the absence of restraint, right? And law, almost by definition, imposes restraints. So how can they possibly coexist, let alone complement each other? Doesn't law just curtail liberty?
It certainly appears counterintuitive on the surface, doesn't it? Liberty as freedom from restraint versus law as the imposition of restraint. The source tackles this fundamental tension head on, acknowledging the apparent conflict right away.
And obviously, we know that a tyrannical state can use law as a tool to absolutely crush liberty. History is full of examples.
Absolutely. The source doesn't shy away from that dark possibility at all, but it argues, and this is the crucial turn, that in reasonably just systems, particularly in democratic and welfare states, the fundamental purpose of law is often precisely the opposite. It's actually intended to protect and promote liberty.
Protect and promote liberty by restricting it. That still feels like a paradox I'm trying to wrap my head around. How does that work?
Here's how the source explains the logic. If we accept liberty not just for ourselves, but as a universal good, something that everyone should ideally possess, then my individual freedom cannot be absolute and unlimited if exercising it would endanger or destroy your freedom. A state of pure anarchy where anyone can literally do anything they want would likely quickly devolve into a situation where the strongest or most ruthless individuals suppress the liberty of everyone else. Might makes right.
Right, the old saying, my freedom to swing my fist ends precisely where your nose begins.
That's a classic illustration, yes. And it captures the core idea. The source's point is that ensuring a meaningful sphere of liberty for all individuals in a society necessitates placing certain restrictions on the absolute unbounded liberty of any single individual. We need rules of the road, so to speak, and law is presented here as the essential means by which these necessary liberty-preserving restrictions are defined and imposed in a structured way.
Ah, okay. So the argument is that law, by defining the boundaries of acceptable action, by drawing those lines, like where your nose begins, actually creates the necessary conditions, the safe space, where liberty can meaningfully exist and be exercised by more people, not just the most powerful.
Exactly. Without those boundaries, liberty for the many would be impossible. The source actually quotes Didi Raphael from his book Problems of Political Philosophy, who makes this point very clearly. Raphael observes that while law undoubtedly restricts our freedom, it requires us to do things we might not want to do, or refrain from doing things we might want to do.
Like paying taxes or not speeding.
Right. He argues that these restrictions are typically intended either to protect the liberty of others or sometimes even our own future liberty or well-being, which would be diminished or threatened by completely unrestricted behavior. Or, alternatively, the restrictions might be intended to promote other important societal values besides liberty itself, like safety, fairness, or welfare.
And for these reasons, Raphael concludes, and the source agrees, that these restrictions, when they are properly conceived and justified, aren't just acceptable trade-offs, but can actually be desirable, even essential, for a flourishing, free society.
Yes. And Raphael goes on, and the source details this, to identify 4 key spheres or areas where law commonly imposes restrictions on individual liberty, but does so in ways that can be considered rational and necessary for achieving these broader purposes of protecting overall liberty or promoting other vital social goods.
Okay, let's break down these 4 spheres the source outlines. First up is the sphere of crime.
Right. In this sphere, the law restricts individual liberty quite significantly. Think about the freedom to just take another person's property or to physically harm them or defraud them. Criminal law restricts these freedoms.
And the purpose is clear: to protect the fundamental liberty and safety of other individuals, and indeed oneself, from harm.
Exactly. Acts that directly threaten this basic security and freedom, things like theft, assault, physical injury, rape, murder, are declared criminal offenses and made punishable under the law. The source also adds an interesting point. Sometimes laws restrict actions that might primarily harm only the individual themselves or their immediate family, like maybe severe alcoholism or drug addiction, or even attempted suicide in some legal systems. These might also be considered cognizable offenses or punishable, reflecting a kind of societal interest in individual well-being and preventing self-destruction, even though that's a more controversial area of restriction.
So the core idea of criminal law is that by saying you cannot do X, Y, and Z, it's fundamentally about creating a zone of safety and freedom for everyone else to exist without constant fear of harm or violation.
That's the rationale. Restricting harmful actions enables broader security and liberty for the community.
Got it. Makes sense. Next sphere. The sphere of civil disputes. How does law restrict liberty here?
This sphere involves the vast area of laws that regulate the private rights and relationships between individuals, or between individuals and entities like corporations. It covers areas like contracts, property ownership and use, and torts, which are civil wrongs like defamation, negligence causing injury, or trespassing.
So the law here restricts the freedom to, say, break your promises in a contract, or carelessly damage someone else's property, or unfairly damage someone's reputation.
Exactly. And the purpose is to define these private rights and obligations clearly and crucially to provide peaceful and orderly recourse when those rights are violated. The remedy here isn't usually punishment like in criminal law, but often things like financial compensation damages or court orders requiring someone to fulfill a contract, specific performance, or stopping someone from continuing a harmful action.
Injunction.
Examples from the source included paying damages if your negligence caused damage to someone's property, or resolving breaches of contract, or addressing issues like spousal harassment within a civil context. Right. And the source also notes that while these are generally civil matters between private parties, some actions within this sphere, like serious fraud or misappropriation of funds or a criminal breach of trust, can be grave enough to also cross the line into becoming criminal offenses. But the main point is that by regulating these private interactions, civil law allows individuals to engage in business, own property, form agreements, and interact socially with a much higher degree of predictability and security. You know your rights are generally protected, and there are established mechanisms to resolve disputes relatively peacefully.
So it sets the rules for private interaction, reducing conflict and allowing people to pursue their interests in projects with more confidence. It enables civil society to function.
Precisely. It provides the framework for peaceful coexistence and cooperation in the private sphere. Okay. The third sphere identified is economic control. Yes, in virtually all modern states, economic activity is subject to quite expensive regulation by law. Law restricts the liberty of individuals, businesses, and other groups in the economic sphere for a whole variety of purposes, maybe to ensure fair competition, or protect workers from exploitation, or safeguard consumers, or protect the environment, or stabilize the economy.
And the source gives examples like labor laws,
Right.
setting minimum wages, regulating working hours and conditions, requiring safety measures, or mandating worker compensation for injuries. These definitely bind employers and restrict their freedom to run their business exactly as they please.
Absolutely. And on the other side, laws might restrict workers' freedom, for instance, by banning strikes in essential public services to maintain public order and safety. The source also mentions regulations aimed squarely at consumer protection, things like quality controls on products, rules about accurate weights and measures, laws against food adulteration. All of these restrict the freedom of businesses or individuals to operate however they might wish, often in order to protect the well-being, safety, or fairness for employees, consumers, or the public at large.
So economic law tries to strike a balance, doesn't it, between the freedom to conduct business and pursue profit and the need to prevent harmful consequences like exploitation, unsafe products, monopolies, or environmental damage.
Exactly. It uses law as a tool to manage the complexities, the power imbalances, and the potential negative side effects inherent in economic life, aiming for what's considered a broader societal benefit or a fairer outcome.
Okay. And the final sphere mentioned is the sphere of social welfare. This sounds like the most proactive use of law to shape society.
It often is. This sphere is particularly relevant in modern welfare states, where law is actively and consciously used as an instrument of social justice and for achieving collective societal goals. This frequently involves restricting individual liberty in areas like how much of your income you keep, taxation, or where you can invest your capital or run your business.
The prime example given in the source is taxation, right? Taxing wealthier citizens more heavily to fund public services that benefit the poor or the community as a whole. Things like public schools, hospitals, social housing, transportation infrastructure.
That's a classic example, yes. Taking from some, restricting their freedom to keep all their earnings, to provide for others or for the common good. Another example the source gives is the government using laws or incentives to oblige entrepreneurs to set up industries in economically backward or underdeveloped areas, aiming to promote regional development and reduce inequality, even if the business owner might have preferred to invest somewhere else purely based on profit motives.
So social welfare law deliberately restricts certain individual economic freedoms in order to actively shape society towards specific social and economic outcomes that are deemed desirable for the community as a whole, like greater equality, poverty reduction, better public health, or balanced regional development.
Exactly. It uses the coercive power of law not just to prevent harm, like criminal law, or regulate interaction, like civil law, but to actively pursue distributive justice and promote collective well-being according to a particular political vision.
Wow. Okay, looking at these four spheres together, crime, civil disputes, economic control, and social welfare, through this framework presented in the source, it becomes really clear how the argument works. Law, despite imposing restraints in each area, isn't necessarily the enemy of liberty. When these restrictions are applied rationally, based on justifiable principles like protecting others, ensuring fairness, promoting safety, or pursuing agreed-upon social goals, law actually seems to be the essential prerequisite for creating a society where widespread, meaningful liberty is possible for everyone and where other important societal values can also be pursued.
That's precisely the conclusion the source draws from this analysis. It argues that the apparent conflicts between law and liberty, or for that matter, between law and morality, are generally resolved or at least reconciled when the restrictions or demands imposed by law are rational. And rational here means they are genuinely intended either to broaden the scope of liberty overall within the society by preventing interference and harm, or to improve societal moral standards and collective well-being.
That's a really powerful argument for the necessary, even positive, role of law in a free and just society. It's not just a necessary evil, it can be a positive good when designed properly. And this idea of rational restrictions and law serving a higher purpose.
Well, it leads us directly to the final vital concept discussed in the source, the rule of law. This seems absolutely fundamental. It absolutely is. The rule of law is considered a cornerstone principle of good governance in most modern political thought. At its very heart, it's about ensuring that governmental power, and indeed all power within society, is not exercised arbitrarily, not based on the whims of rulers or officials, but is instead constrained and guided by established known laws. It requires certain specific conditions to be met to prevent that kind of unchecked, arbitrary authority.
Okay, so what are those essential conditions? What does the source list as required for the rule of law to actually exist in practice?
The source lays out 4 key requirements pretty clearly. First, the law itself must be properly notified to the citizens. People need to know what the law is, what its content and effect are, before they can be expected to obey it. No secret laws.
Makes sense. You can't follow a rule you don't know exists.
Exactly. Second, laws must generally be general in form. This means they should apply uniformly to all citizens, or at least to all citizens, within a clearly defined category relevant to the law's purpose. There shouldn't be specific laws targeting or exempting particular individuals or small groups without a very strong, objective justification related to the law's aim. No laws just for political enemies, for example.
Equality before the law in that sense.
Yes. Third, laws should ideally not be applicable with retrospective effect. You shouldn't be punished today for doing something that was perfectly legal at the time you did it just because the law changed yesterday. That allows for arbitrary punishment.
Right, that seems crucial for predictability and fairness.
It is. And fourth, and perhaps most importantly, governance itself. The actions of the state, of officials, must be exercised strictly according to the law. Government must follow established procedures, adhere to legal principles, operate within the constraints set by law, rather than acting based on personal whims or political expediency or any other arbitrary basis.
So the government itself is bound by the law, just like the citizens. Officials aren't above the law. Citizens should only be punished for breaking known laws after a fair process. And someone's official status doesn't give them a free pass if they break the law themselves.
That's the core implication, yes. No one is above the law. The source prominently features the work of the eminent British jurist A.V. Dicey here. His book, Introduction to the Study of the Law of the Constitution, published back in 1885, is hugely important. Dicey is often credited with popularizing the term rule of law in the English-speaking world and identifying it as the fundamental governing principle of the British Constitution.
And his core meaning, the essence of the rule of law for Dicey, was primarily about equality before the law.
Yes, that was central to his understanding. He saw it as requiring the equal subjection of all classes of citizens, and this explicitly included government officials to the ordinary law of the land. And crucially, he emphasized that this ordinary law should be administered by the ordinary courts of the land.
And he famously contrasted this with the French system of his time.
He did. He contrasted the English system, where an official who committed a legal wrong against a citizen would be sued or prosecuted in the same ordinary courts as any other citizen, with the French system, as he understood it then, which had a separate system of administrative courts, droit administratif, to handle disputes between officials and citizens. He saw the English system as providing better protection against arbitrary official action because officials weren't shielded by special courts or special laws. They were subject to the same law in the same courts as everyone else.
Although the source adds a slight clarification or nuance here, doesn't it? It notes that Dicey's comparison shouldn't be taken to mean that French administrative law wasn't ordinary law in the sense of being a proper part of their legal system.
Exactly. The source clarifies that the fundamental difference Dicey was highlighting was primarily in the judicial organization specialized courts in France, versus ordinary courts in England for handling disputes involving officials, rather than suggesting the French system lacked lawfulness altogether. It was more about the structure, ensuring officials were held accountable under the same general law.
Okay. Now, in the specific English context, with its largely unwritten constitution, the source notes there isn't a single document with a formal list of constitutionally guaranteed rights, like you see in the U.S. Bill of Rights or other written constitutions.
Right. And Dicey saw this not as a weakness, but potentially as a strength, in a way. The source explains that the robustness of the English system, in Dicey's view, lay in the fact that the actual remedies, the benefits, the liberties enjoyed by citizens weren't just abstract declarations, but were embedded in and protected by their ordinary law. The law developed through specific statutes passed by Parliament and through the precedents set by the ordinary courts over centuries in concrete cases.
So, the broader meaning of the rule of law for Dicey, according to the source, was best understood not by looking for grand constitutional guarantees, but by examining how English ordinary law actually dealt with protecting specific rights in practice rights, like personal freedom from arbitrary arrest, freedom of discussion, the right to public meetings, ensuring government finance was controlled by law, holding ministers responsible under the law.
Yes. In essence, for Dicey, the rule of law in England was fundamentally grounded in the concrete legal protection of individual rights provided by the regular functioning legal system itself.
And while the British Parliament technically has unrestricted legal sovereignty, it can legally make or unmake any law. The source points out that this absolute legal power is significantly constrained in practice by powerful unwritten constitutional conventions. These conventions ensure that the legal sovereign, Parliament, remains politically accountable to the ultimate political sovereign, the electorate. That accountability acts as a crucial check.
Exactly. It's part of the broader understanding of how the rule of law operates within that specific system.
Now, in other democracies, particularly those with written constitutions like the United States or India, individual rights are often explicitly spelled out and enshrined as constitutional guarantees.
And the source views these constitutionally guaranteed rights as essentially concrete embodiments or expressions of the same fundamental principles that underlie the wider interpretation of the rule of law. They serve as a higher legal standard against which ordinary laws and government actions can be measured, providing an explicit safeguard against arbitrary power and ensuring those core tenets of fairness, equality, and predictability are upheld.
So pulling it all together, in common parlance today, when we talk about the rule of law, it really boils down to that core idea. Laws should be definite, they should be unambiguous, clearly published and notified, known, or at least knowable, to everyone they affect, and perhaps most importantly, they should be equally applicable to all citizens, including the government itself.
Yes, though that equally applicable part needs that slight nuance we discussed, which the source points out again. It doesn't mean the law must treat every single person identically in every single situation, ignoring relevant differences or contexts. The traffic regulation example is perfect for illustrating this.
Right, remind us of that one.
Well, the idea is that everyone using the road is subject to the same general body of traffic law, but the specific rules within that law naturally distinguish between different types of vehicles, cars, trucks, motorcycles, bicycles, and prescribe different behaviors appropriate to each, like speed limits, lane usage, required equipment. The rule of law in this context requires that every road user is aware of the rules that apply to them: which side to drive on, how to signal, rules about giving way, overtaking, stopping. The law applies universally to all road users in the sense that everyone is bound by a rule, but the specific requirements are tailored to the nature of the activity, driving a car versus riding a bike, and the vehicle involved. The law might even give priority to certain vehicles, like ambulances or fire engines, but only under specific defined conditions, like using sirens and lights. The crucial point is that the rules are known, predictable, and applied consistently based on these defined, relevant categories, not arbitrarily decided by a police officer on the spot based on who they like or dislike.
Okay, that clarifies it perfectly. The rule of law isn't about blind, rigid identicality for everyone in all circumstances. It's about fair, predictable, and impartial application of clear, known rules based on relevant distinctions, ensuring that everyone, including the government and its officials, operates within and is held accountable to that established legal framework. It's the bedrock safeguard against arbitrary power.
Precisely. It's the fundamental principle that underpins a just, stable, and predictable legal and political system. It ensures that power is exercised under the law, not above it.
Wow. Okay. This deep dive into just this one source has given us a really rich almost panoramic understanding of the concept of law. It's incredible how much ground we've covered. We've moved from that basic but crucial distinction between descriptive and prescriptive types of law,
The starting point.
then explored four fundamentally different philosophical perspectives on what law's essential nature even is: natural law appealing to higher reason or morality, analytical jurisprudence focusing on structure, validity, and authority, the historical school looking at its evolutionary growth from custom and culture, and the sociological school viewing it as a tool for social purposes. We got a real sense of the core idea driving each one.
Seeing those contrasts is really illuminating.
Yeah. Then we looked at its varied origins, going beyond just government decrees, seeing how deeply law is rooted in custom, in religion, how it's shaped by profound intellectual thought and scientific commentaries, how it grows through practical adjudication and the fairness principles of equity, and of course, through deliberate legislation.
Multiple streams feeding the river of law.
Exactly. Then we grappled with its often tense but absolutely essential relationships with morality and liberty, seeing the argument that rational laws, despite restrictions, can actually promote both overall liberty and societal well-being.
Reconciling those apparent opposites.
And finally, we've landed on this vital principle of the rule of law, understanding the specific conditions required for it to function: publicity, generality, non-retroactivity, governance according to law, and how it serves as that fundamental protection against arbitrary power.
It really does highlight, as the source makes clear, that law is far from being a simple, singular concept. It's this complex, multifaceted idea that's been debated, developed, and understood in radically different ways over centuries. Different thinkers, different schools focus on its moral basis, or its structural validity, or its historical evolution, or its social function, or its diverse origins, or its crucial role in balancing order with freedom and justice. This source material really lays out all these different lenses we can use to view the legal landscape around us.
Absolutely. And understanding these foundational ideas just from digging into this one text can absolutely change how you read the news, how you think about political debates, maybe even how you see the rules operating in your own community or workplace.
Law.
Law is everywhere, right? And knowing these different facets, these different ways of thinking about it, it empowers you to look beyond the surface and understand the deeper principles, the historical context, the philosophical assumptions, and the ongoing tensions that are always at play.
It definitely provides a much more robust framework for critical thinking about the rules that shape our lives, why they exist, and whether they're serving the purposes we think they should.
So here's a final thought to leave you with, drawing from what we've discussed based on this source. Thinking about how the source shows law can grow organically from things like custom and changing social consciousness, or how some thinkers see its core purpose as social engineering or enabling universal liberty. What does that imply about your role as an individual member of society in potentially shaping the law, or at least shaping the conversations and the moral consciousness around it for the future?
That's a great question. Or maybe consider this. Given the fundamental disagreement we saw, even among brilliant legal minds within analytical jurisprudence, about whether morality is truly part of law's definition or completely separate, how do you personally decide when a law, even if it seems perfectly legally valid according to all the official rules of the system, might still feel fundamentally wrong or unjust? Where do you draw that line for yourself?
Those are definitely questions worth mulling over long after this deep dive ends. Thank you so much for joining us as we unpacked the complex and absolutely vital concept of law, drawing insights straight from this foundational source material.
It was a pleasure. Keep exploring those big questions.